This case opens with immediate stakes: a defendant, a criminal history, and a baby whose future could be decided by what happens in this courtroom. You're about to see a judge balance law, rehabilitation, and child safety, while making it clear that second chances come with strict limits.
Can I fake my baby with me?
No, what ends up happening, someone needs to be there to accept custody of your child. Otherwise, Child Protective Services will be picking up your baby and you will have a CPS case. And when you're released from— Could I have parties announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
Deborah Stanton, defendant.
And are you Miss Butler?
Right away, the court explains something many people don't realize. If no approved adult is present to accept custody, CPS steps in immediately. This isn't a threat to its procedure. The judge is laying out the consequences before emotions take over later in the hearing.
All right, and according to your plea bargain agreement, there's a $1,500 fine. The state is recommending deferred adjudication. This is the run concurrent with 718-359 and 72869. The state is taking in consideration NIMAC number 752652.
This is the legal foundation of the case. Deferred adjudication means no conviction yet, but the court keeps full authority to revoke it. Every fine, every concurrent case, and every condition listed here is a warning that this opportunity is fragile.
760865. All right. So if you were released from custody, who would you be staying with?
I'll be staying with my mother.
All right. And people will say that, but have you picked up the phone and called her and she wants you to stay with her?
Yes.
When she admits she's already lost custody of her child, the courtroom tone changes. This is no longer theoretical risk. The judge now has proof that instability has already consequences, and that weighs heavily on every decision that follows.
All right, now she's under oath. Okay.
After her, I want to tell you something about me and her mom.
Okay. All right. Thanks. So do you have any children?
Yes, I have one son.
And what is his age?
His age is 2 years old.
This moment matters. The judge isn't dismissing her dream of becoming a nurse, explaining how criminal records complicate licensed careers. It's a blunt reminder that motivation alone doesn't erase past choices, and progress must be demonstrated, not declared.
And who does he live with?
He is not in my custody anymore.
Okay.
Yeah, I lost my rights.
Okay. And so what are your plans as far as employment? What are your hopes, your dreams, your goals?
My goals is to be a college graduate. I want to be a nurse, a RN. So when I get out, I do want to start school. I was already enrolling in the process, and then get a job.
All right. So what I can tell you is it's not impossible, but it's difficult. Anytime you have a criminal case, whether it's deferred or regular probation with a conviction, when you're seeking employment somewhere where it requires a license, it becomes more difficult. But it can be done, because I know someone who actually went to prison, and I know this because—
Here's where the court draws firm boundaries. No unsupervised contact with minors, drug testing, employment restrictions, and structured supervision. These aren't suggestions, they're safeguards. The message is clear: compliance is the price of freedom.
I work with them to try to get their license and everything. Guess what? They're now an attorney. So it can be done, but you just made it a struggle, okay? All right. Did you all want to speak to the length of deferred adjudication? It's in the plea paperwork outside the agreement. It's for 4 years.
Anything up to 4 years.
All right. So I'm going to set your deferred adjudication at 4 years deferred adjudication. If you complete everything successfully, you can always approach the court for early termination. But for early termination, I'm going to be looking at whether or not you've been positive, whether you've been reporting on a regular basis. You understand?
Yeah.
So there's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, and I'll say 30 days of release.
Yes.
There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And the no unsupervised contact with minors, That can potentially change once you've shown me that you have everything, your life together. You understand?
Yes.
This will run concurrent with 718-359 and 728-369. Taking consideration NITMAC number 752-652, 760865. Field visits one time per month for 6 months. 200 hours of community service restitution. If you complete a higher level education, or if you obtain some sort of trade school certificate, the community service hours will be deemed satisfied. So it'll be up to you whether you want to end up picking trash up on the side of the road or bettering yourself with your education. You understand?
On the school, yes, ma'am.
There's to be no contact with Longley, Longle. There is a $1,500 fine that will be probated. And I'm going to follow the TAP recommendation, and that's to be dual diagnosis, outpatient treatment with probation. And there's going to be 60 sober meetings in 60 days. And then we can go off the record. So in this court, communication is complete.
Yes, ma'am.
If there's an issue, let probation know. If you feel as though they're not a good case, always come back to the court. This is what I tell everybody. My goal is to be rehabilitated. If you feel as though you're going to take a drink, because you're not allowed to drink alcohol on probation or do any other type of drug, pick up the phone, call your probation officer, say, I'm struggling right now. Because that shows me that you learn.
This is the turning point. By pleading true to the violation, the defendant hands the judge full authority to impose jail time. There's no negotiated deal here, only discretion. From this moment forward, everything depends on what the court believes is safest.
What you need to do in order to stay clean and sober. But if you're out here in this world and you're having problems and you don't let them know, guess what? We don't know, and we can't help you. All right. Is there anything else you need from the court in order to be successful?
No, ma'am.
All right. And you want to tell me about her mom?
She and I are texting every day. She wants to know what happens now, today. So, yes, her mom's here.
All right. So they'll probably release you. It's probably going to be midnight. I have no control over
We
that.
have to make sure she's on bond in the
Okay.
2 county court settings.
So if you make bond for that, this court is not the court that will be holding you. It'll be the misdemeanor court. Okay.
Okay. Yes, ma'am.
All right. Thank you. Court is calling 2024 CR 4982 State versus Briella Butler. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor. Patrick Collins for the defense.
And are you Ms. Butler?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Briella Butler who's placed on deferred adjudication in 2024 CR 4982 for the offense of forgery of a financial instrument on February 12th, 2025 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violate condition number 1 on or about the 22nd day of May 2025 in Bear County, Texas. The defendant, Briella Butler, committed the offense of possession of a controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True.
I'm sorry, was that true?
True.
Thank you, ma'am. We'll waive the remaining violated condition, Your Honor. Yes, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
No, Your Honor, it's unagreed.
All right, state, what are you requesting?
The state is requesting adjudication of guilt and revoke for community supervision for 18 months in the state jail facility. One part of the agreement, we are taking into consideration the possession case she just pled to, which is JN 7143967. And we're also taking into considerations a county court at 2 case 2025 CC 011626, which is a failure to ID.
All right. In defense, what are you requesting? Oh,
Your
you
Honor.
can't sign that.
Well, this is the
This is, okay.
Your Honor, we're requesting that you continue her on probation, to deny the motion, and to follow the recommendation by probation to send her into the MIC unit or some other type of supervisory program with zero tolerance.
I really don't normally do zero tolerance in this court because being on probation, you're supposed to follow the rules. So my question for you, or maybe for her, what have you done? Because you've been on probation since February. What have you done? Have you completed?
This exchange is devastating. The judge directly connects drug use, pregnancy, and custody consequences. The court isn't speculating, it's explaining exactly how the system responds when these factors collide, including CPS involvement and mandatory parenting requirements.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand, state your name for the record.
Briella Butler.
What have you done?
I went to the 60 days NA or AA online virtual visits. I reported twice.
All right, so that didn't work because you're here for a possession of controlled substance. What was that controlled substance?
Methamphetamines.
All right. So we know that doing the 60 days didn't work because you have a possession of meth. And how far along are you in your pregnancy?
7 months.
All right. So what that means is you're doing drugs.
No, ma'am, I wasn't.
Who did the meth belong to?
DeAndre Hartley. I have an affidavit that they brought in.
Mm-hmm.
It wasn't mine. I did stay at the scene when the cops came. My car, I just bought it. It was broke down, and I was at my mom's house. And cops pulled up, and when they pulled up, my friend ran off, and they immediately put me in handcuffs and searched the car.
So let me just tell you right now.
And
The only way you're going to be continued on probation if you go into inpatient treatment. We're not doing this zero tolerance thing. So she can either go into inpatient treatment, and because you're pregnant, they will accept you at safety. But they're not going to accept you at any of the programs because of how far along you are in your pregnancy. So you can either do that or you can do the 18 months.
okay. Thank you. Can I take my baby with me?
No, what ends up happening when you are at safety, because it's at the prison, when you're at safety and you deliver your baby, someone needs to be there to accept custody.
In the end, the court chooses treatment over prison, but under custody and strict supervision. This case shows how close rehabilitation and incarceration really are. If this hearing made you think, hit like, share your thoughts below, and subscribe for more real courtroom breakdowns.
Your child. Otherwise, Child Protective Services will be picking up your baby and you will have a CPS case. And when you're released from safety, that's what will happen. You will have to do parenting classes and everything else that's required of you. And when you have somebody, if you have your mom or whoever it is to come pick up your child at the prison, they will make a determination on whether or not that person is appropriate or not. All right. So the court will deny the motion, alter and amend conditions to include safety. Probation, is there anything you recommend other than safety? All right, so there'll be safety, and that's, of course, is in custody. And then it is 9 months. And you have to wait. What's the wait time for safety? All right, so usually the wait time for safety normally is 3 months. So you'll be waiting at the jail for 3 months, then they'll transfer you to safety and you'll be there for 9 months. All right, so the court is going to deny the motion alternate amending conditions to include safety. Once she is released from safety, she's to be placed on the MIC caseload, and there's to be no unsupervised contact with minors, field visits until further notice. She's to complete parenting classes. Court will take in consideration JN 7143967 and 2025 CC 011626. All right. Is there anything else?
Nothing from us, Your Honor.
All right, thank you.
Thank you, Your Honor.
Yes.
On the until we just heard, given that she's 7 months pregnant, they wouldn't accept her because she has to be less than 20 weeks pregnant for a transport to see. Did you want to hold it in advance?
No. Then she's going to felony drug court. And if she doesn't go to felony drug court, then she's going to remain in custody.